Hello there, I'm attorney Kelly Longtin, founder of Kelly Longtin Law. And today this video is going to talk about marital disclaimers and the Clayton election. So these are two options that are used to do some estate tax planning. So a little bit more technical than some of the videos you might find on here, but equally as important. So deferring or minimizing or avoiding estate taxes altogether is often an important estate planning goal for married couples. However, uncertainty surrounding what the estate tax laws and the value of their accounts and property will be at the first spouse's death can leave a couple feeling that they need a crystal ball to kind of make the right decisions when it comes to these tax planning strategies. Using either a disclaimer or the so-called Clayton election as part of their estate plan can allow at least some hindsight and consequently peace of mind. Before diving into some of the particulars of using a disclaimer in the Clayton election, let me first lay some conceptual groundwork. The main objective of using a marital funding formula in estate planning is to take advantage of both the estate tax marital deduction and the estate tax exemption to eliminate the federal estate tax due at the death of their first spouse, and to reduce or eliminate federal estate tax due after or at the point where the surviving spouse then later passes away. So what is the marital deduction? In general, as long as your client or you meet the requirements under federal estate tax law, transfers from a decedent spouse to a surviving spouse, provided the surviving spouse is a U.S. citizen, are excluded from the decedent spouse's estate and are not subject to estate taxes at the first spouse's death. This is the unlimited estate tax marital deduction. The unlimited estate tax marital deduction essentially postpones the payment of any estate taxes until after the second spouse passes away. The general concept of the estate tax exemption is that if the value of your estate is less than the exemption amount, no federal estate tax is due. Now, the 2022 exemption amount for an individual is $12.06 million. So under current law, the exemption amount will be reduced to $5 million, although that will be adjusted for inflation on January 1st, 2026. It's set to fall back. Currently, 40% tax is imposed on the estate to the extent that its value exceeds the exemption amount. Now, marital share funding formulas use both concepts to eliminate federal estate tax to the greatest extent possible. In essence, because the unlimited estate tax marital deduction allows estate tax liability to be postponed until the second spouse's death, the first decedent spouse's estate plan should use a formula to divide their estate into two shares. One is the marital share, which is part of the decedent spouse's estate that passes to the surviving spouse in a form that qualifies for the unlimited estate tax marital deduction. And two, the non-marital share, which is part of the decedent spouse's estate that does not qualify for the unlimited marital deduction, but is instead sheltered by the decedent spouse's remaining estate tax exemption amount. So let's talk about disclaimers. Now, there's numerous different ways to divide a couple's trust property into marital and non-marital shares upon the first spouse's death. But the disclaimer option gives the surviving spouse the most flexibility. Using the disclaimer option, the trustee or the executor distributes all of the decedent spouse's trust property to the marital share. The surviving spouse may then exercise a qualified disclaimer, which is just a refusal to take ownership of money or property left to them by their deceased spouse under the IRS Code Section 2518, and the trustee distributes any property disclaimed by the surviving spouse to the non-marital share, which can either be held in trust for the benefit of the surviving spouse and other beneficiaries if desired, or otherwise administered under the trust agreement's residuary provisions. With the disclaimer option, the surviving spouse can choose to give any amount or property they wish to the non-marital share, depending on the estate tax law in effect at the time of the first spouse's death, the value of the decedent spouse's estate, and the surviving spouse's financial needs. So let's talk about the Clayton election. The Clayton election is actually named after a court case, the estate of Clayton Jr. versus Commissioner, and is another formula used to divide a couple's trust property into marital and non-marital shares. It also provides maximum flexibility to engage in marital education planning after the first spouse's death. The way the Clayton election works is almost the opposite of the disclaimer option. Instead of distributing all of the decedent spouse's trust property to the marital share, the trustee distributes it to the non-marital share. The trustee may then list any property on Schedule M, bequests, etc., to the surviving spouse, which is the marital deduction, of the decedent spouse's IRS Form 706, which is the federal estate tax return, to allocate it to the marital share instead. Now, an advantage of the Clayton election, in contrast to the disclaimer option, is that its technical requirements and timelines are less rigid. While a disclaimer must be made within 9 months after the first spouse's death, a Form 706 is not due until up to 15 months or possibly 24 months if the executor is not required to file an estate tax return, but files to elect portability after the first spouse's death, allowing more time to grieve and for making it a less emotion-driven decision. Another advantage of the Clayton election is that it allows someone other than the surviving spouse to objectively decide what property should be apportioned to the marital and non-marital shares. In addition, because a Form 706 must be filed when using the Clayton election option, there is an opportunity to claim for future use any unused amounts of the decedent spouse's estate tax exemption. Finally, because the Clayton election sends the decedent spouse's property into a non-marital share trust by default, the surviving spouse automatically receives those accounts and property in a form that offers a degree of creditor protection. So whether to use the marital formula in your estate plan and which marital formula to use, it requires, and you need to consider an analysis of your estate, your goals, and the law in the state in which you live. So if you live in Massachusetts or New Hampshire, please contact us to put a plan in place or to review the strategies that you have to make sure that your estate planning meets all of your goals, including deferring, minimizing, or eliminating the estate tax that your heirs will have to pay from your estate. So I want to thank you for watching. I hope this was informative and educational when we talk about disclaimers, Clayton election, and tax planning. I'm attorney Kelly Longtin, founder of Kelly Longtin Law, and I thank you for watching.